Good morning, everyone. Welcome to the First District Court of Appeals. We have several cases on the docket today, but the only one being argued is State versus Hall. Ms. Glazer, Ms. Adams, welcome this morning. Ms. Glazer, how much time would you like for rebuttal?
I'll reserve 3 minutes, Your Honor.
Okay, very well. You may proceed when you're ready.
Thank you. May it please the court, Ms. Adams. This is well-charted territory for the courts on this issue. While this case was pending, this court decided Hollis v. State, which I believe is applicable precedent for this case. In looking at that case and the other cases that the First District have decided, such as Phipps and Doe and relying on Collier, the court's going to just do a substantial equivalence comparison of the two statutes, looking at the mens rea, the age of the victim, the age of the perpetrator, and the conduct that is prescribed by the two statutes. So in using that test, that substantial equivalence test, and looking at the two statutes here, they differ in a number of ways, and one of which is the age of the victim. So if you're looking at the gross sexual imposition statute in Ohio, the victim must be less than 13 years of age, while in Kentucky for sodomy, the victim must be less than 14 years of age. And that was one of the factors relied upon by the court in Hollis, the difference of the age of the victim in that case. Additionally, there's no age.
So certainly there are some differences between the statutes. I guess part of my question from an analytical perspective is, if the conduct in the foreign state, in this case Kentucky, even if the statute is different, if the conduct perpetrated would be punished the same way under Ohio statute, how should we consider that?
Judge, I don't believe that the applicable case law looks at the penalty in these cases and the prior analysis. In fact, I wish I could think of which case discussed the fact that courts did not look at a penalty. When considering, I think that's out of the First District, that the penalty itself does not matter.
Yeah, I'm sorry. Don't focus on the penalty, but I'm saying whether if the conduct prescribed under the foreign state would also be prescribed in the conduct perpetrated by the defendant would also be prescribed under the Ohio statute. Is that enough for substantial equivalence?
Judge, I would argue it's not enough. I don't think this is a case where the court's required to consider other evidence besides just the statute itself. I know there is, in limited cases, the case law says that the court would go beyond the statutes and look at the actual conduct. What I'm asking the court to consider is just a strict comparison of the elements of the offenses themselves. But I think even if this did fall under one of those limited cases where the court could consider other evidence besides the statute, such as the indictment or other important charging documents in this case, the indictment itself says, while 18 or older, did engage in deviant sexual intercourse with less than a 14-year-old. In Ohio, for gross sexual imposition, it has to be the victim has to be less than 13. So Kentucky is encompassing more or broader conduct than what the gross sexual imposition statute allows. And that's pretty much in line with Hollis. Florida encompassed more conduct based on the age than Ohio did. And Doe, Florida encompassed more conduct. And Phipps, New York encompassed more conduct because the victim could be 17 or less, whereas
what conduct would be illegal in Kentucky but legal in Ohio?
So if you look at the Kentucky sodomy statute, if the person's 14 here, they're not going to be convicted of gross sexual imposition, and that's the statute that the state argues sodomy is equivalent to. So I would argue that they've abandoned any argument about that statute meeting any other substantial equivalence test besides GSI. I know at the trial level, the state had argued that it may also be equivalent to sexual battery, but that was abandoned in the state's appeal, and instead relied on the gross sexual imposition. And the reason why I believe that is because attempted or sexual battery is even less equivalent than GSI would be, because if you look at Doe, they said that attempted sexual battery was not equivalent to a number of other offenses, and that's because it either requires force or a relationship. And that just simply wasn't present here in the indictment or in any other document that the court could consider.
Does the Supreme Court's intervening decision in Lingle impact this analysis at all?
Judge, I would argue it does not. And my interpretation of Lingle is that the courts do this substantial equivalence analysis, and the defendant, or in this case, the petitioner, no longer has a right to a hearing when they come from out of state and they come in based on whether or not they're likely to commit another offense in the future. Instead, they just want the courts to see why they have a duty to register in that other state and if it's substantially equivalent to an Ohio offense. And because the first district has already done such a great job of outlining this substantial equivalence test, I don't think it changes the case law on this issue at all. And I think that the first district has already defined what substantial equivalence is. And that's what I'm asking the court to apply to Ms. Hall and find that she doesn't have a duty here.
So the only real difference is the age, right? Because we have the same, a lot of cases had issue with the mens rea piece of it. And we have the same mens rea in both statutes, correct?
So, Judge, as far as the mens rea, under the gross sexual imposition statute, there are sections that require an element of purposely, and there are sections that are strict liability.
But we're only looking at one particular section in this case, right?
I would argue that you look at the entire statute when deciding substantial equivalence. You look at each element of the statute itself versus the Kentucky statute, not what subsection you believe Ohio would proceed on if they were attempting to convict someone on an offense.
But I mean, some statutes implicate a wide range of conduct. And if we were required to look at it from that level of generality, then it would seem like it'd be very difficult to have to satisfy the substantial equivalence test.
I mean, Judge, you have a good point, and there's probably not going to be statutes in other states that have identical language. But the four factors that are laid out by the case law, I think there are more differences than just the age of the victim itself. There's also in Ohio no age requirement for the perpetrator, whereas in Kentucky, they must be 18 or older. There's also different type of conduct. In Ohio, it's intercourse and oral versus Kentucky. They talk about deviant conduct, and deviant for them is described in a different way than Ohio describes intercourse. It's specifically meant to limit oral and anal conduct.
But wouldn't the
wouldn't the-
Ohio statute cover that? I mean, it's broad, right?
Well, yeah, Ohio intercourse would encompass I believe the anal element, yes. But it's
So that goes back to my question. The real issue in this case, and tell me if I'm getting this wrong, but the Kentucky statute protects 13-year-olds, but the Ohio statute does not.
Kentucky protects 14 and younger, and Ohio is 13. So
Less than 14.
yeah, less than 14.
So it wouldn't be a 14-year-old. It would be Kentucky protects a 13-year-old.
Correct, Judge. I'm sorry.
Ohio does not, right?
Yeah, Ohio does not. It would be 12 and under. So if you're if the victim's 13, you're not going to be convicted of gross sexual imposition in Ohio. It might be some other offense, but there's no other offense that the state's arguing that would be equivalent to here.
There's conduct in Kentucky that is illegal that would be legal in Ohio.
Well, again, I think if you engaged in a sex act with a person that's 12 in Ohio, certainly there would be some statute that the state would try to proceed on to convict a person. But I don't think that's the analysis that the first district has laid out for these cases. I think, it's just a strict comparison of the statutes themselves. And that's what you use to determine whether they're substantially equivalent. And I think even if you go beyond that and you look at the indictment in this case, I still don't think the two statutes are substantially equivalent. And there's a number of
Counsel, if we do look beyond the statutes themselves, are we limited to just the indictment?
It's not just the indictment, and there were a number of other documents that were submitted at the trial court level by the state that I would argue the court should not consider, such as registry documents after the conviction itself. I think, what the court has said is that you can look at a limited portion, including indictment, court documents, but this wouldn't include police reports, for example, or other unsubstantiated documents. An indictment or another court verified document, certainly you could look at, but not the registry forms or anything following a conviction or any allegations in a police report, for example. It's supposed to be just the conviction itself. If that answers your question. I'm trying to think if I have anything else to talk about. If there's no further questions, I think I'll submit on my brief.
Okay, thank you very much. Ms. Adams?
Morning, Your Honors, Ms. Glaser. I think that one thing that it's hard for this court to rely on the precedent from the other cases that have been decided by this court, because you're looking at those particular states' statutes. And as Ms. Glaser mentioned, there's different languages used by each jurisdiction with regard to states. I think that when we're talking about this particular case, we are limited in looking at whether or not the subsection that the trial court looked at and she analyzed and found to be substantially equivalent is substantially equivalent to the Kentucky statute. Now, obviously in Ohio, we distinguish between contact and conduct. So that's sort of the difference that we would be looking at if we were comparing sexual battery, because that's a conduct. But certainly when you engage in instances of sexual conduct, and so when you look at Kentucky, the deviant sexual behavior, that's going to encompass both contact and conduct, obviously. So really, truly, the only difference, as Judge Krause pointed out here, is the age. And in this court, the prior cases that you all have looked at, the age was more significant because most of those statutes we were dealing with the unlawful sexual conduct with the minor type of offenses and the differences between the other jurisdictions and ours. And certainly that strict liability was a huge hang up in looking at, excuse me, I'm sorry, that they weren't substantially equivalent. And
it seems like those cases focus on obviously the age of the victim and the perpetrator, but also the mens rea, and those were kind of three factors that they looked at and said, well, these are enough differences that takes it out of the substantially equivalent realm. But here we have the differences in ages on both, and then we do have difference in conduct. So, like, is under that case law, why is that not enough?
Well, I don't believe that we have a difference because we're not talking about conduct, we're talking about contact. So certainly the language that's covered in the definition of deviant sexual behavior in Kentucky subsumes what would occur or what the definition of sexual contact is in Ohio. And I think it's important to emphasize that the Ohio Supreme Court's decision in State versus Lloyd allowed for there to be a non-exact match. And that seems to be what Ms. Glaser's case is pointing out, that we have a strict matchup of the elements here. And that's certainly, it's going to be the rare scenario where you would have an exact match.
But didn't Lloyd then, I mean, there was an exact an inexact match in Lloyd. So then the Supreme Court went and took looked at the second level of the analysis and compared what actually happened. So, I mean, that's what the Supreme Court advised us to do in Lloyd.
Correct. And providing the definition of substantial equivalent, they said that they expressly leaves room for potential distinctions. So certainly that potential distinction here is the age differences in the two statutes. So I think if we look at that definition of substantial equivalence, that is certainly met in this case. Now,
So
anytime.
are you saying that it's such a minor difference that we don't have to go and look at the underlying record? We just compare the statutes on their faces?
I think the court can do that, but and I've urged this court to do this all along in all the other cases that I've not been successful in, is that when we have cases where you have those age distinctions in the statutes, obviously that makes sense to go on and look outside the statute. Because when we're talking about having sexual contact or engaging in conduct with toddlers, what's it matter if they're 14, 12, 13? It's illegal behavior. But
I guess
it's not legal to have sexual contact with a toddler.
Counsel, I'm going to ask you the same question that I asked Ms. Glazer. What are we allowed to look at outside of the record or outside of the statute?
Well, in Lloyd, that's all set forth. I believe they mentioned such things as, well, the charging documents, bills of particular. And when what happens?
I'm talking specifically in this case. What are we allowed to look at?
In this case, everything that obviously the trial court had before it. And what's important here is that the record is going to have the entire hearing that took place, and what the matter that's being appealed here is she's pulled out and isolated just the trial court's ruling on the what was substantially equivalent. So when the trial court is conducting this hearing, they have that information before them. And I don't believe, I'm looking to see if I listed everything that was considered. I do know that there was expert testimony that was provided in this case as well. So certainly the facts, to the extent that they relied on by the expert, and the expert's getting that if they evaluate the defendant, any documents or collateral sources that expert has. So there's going to be, the record in this case contains a lot of information with regard to the facts of the case. That's because the trial court went on to consider the next prong. So it's hard to isolate the record in a scenario like this when the court went on to hold the hearing, but they're only appealing from the substantial equivalent analysis.
So you mentioned that this case involved a toddler, so it really renders the age irrelevant. But I guess, my concern is if we were to say on the face of it that these two statutes are substantially equivalent, but there are differences in age, couldn't that allow for a different circumstance where the conduct might not be covered by the Ohio statute? And we've already said it's completely substantially equivalent. So doesn't that create some issues?
I don't believe it does. Again, like I said, when I think it's important when we're looking at when age matters in the statutes, obviously common sense would say, okay, how old was the victim? How old was the defendant in this particular case? So the state would urge this court to adopt an opinion that allows for that. When there is those differences just in the age, we should look at what behavior, what conduct occurred that the person was prosecuted or convicted.
So in other words, you're not advocating a result of this case that we would say as a matter of law, these two statutes are for all purposes substantially equivalent.
Either way, I think that I do think that the differences are minute enough for this to meet the definition of substantially equivalent, because it's not an exact match is not required even within the definition. But again, for future cases, the state would urge this court to be looking ahead a little bit and allowing for not a strict comparison, especially when we have age. We seem to be coming across this a lot where Ohio will just say no person. Other states say no person over the age of 18. Now, I don't know if those other jurisdictions have a different statute for juveniles that would encompass their criminal conduct or their delinquent behavior. I think that's occurred, I think, in New York. So I think it puts our courts, our trial courts that are trying to comply with this at a disadvantage when you have little minute things like that that you have to get past. And again, it may be simplified by this court simply saying when age is a relevant element set forth in the statutes, that is one of those scenarios where the court would then need to look beyond. But in this case, I don't think it's completely necessary because I think that the statutes are substantially equivalent. They meet the definition of substantially equivalent.
If we agreed with you, would this case have to be remanded for a legal consideration? Because I know there was a hearing held about under the old law in this particular case, right?
Yeah, I don't know of any case that I've ever come across in Ohio where we would have looked at what Lingle says to look at why they were, put at the highest level. So in an abundance of caution, I'll say yes, likely. But without having read that, I would be surprised if this trial court looked at that factor because I don't know of any that had been prior to Lingle.
Yeah, I don't think the trial court did. I think that there was a hearing held about recidivism, right? Or likelihood of, right.
That's why there was an expert.
Which you can't have anymore.
Right.
Okay.
Unless the court has any further questions, I'll submit.
Great, thank you, Ms. Adams. Ms. Glazer, you have 4 minutes.
Thank you, Judge. There was a hearing at the trial level regarding whether or not she was likely to recidivate in the future. Those are the cases that I think probably have to be remanded if that's an issue that's included in the appeal. That specifically was not raised in the appeal, the hearing issue. So I don't think the case needs to be remanded because Lingle is asking courts to make this analysis that's basically being argued here by Ms. Adams and I today about whether or not the two statutes are equivalent. I believe that we're in a position where the court can issue a decision and she either has a duty to register for the rest of her life here or she does not have a duty to register. But what I would urge the court not to do, and I think.
Well, in other words, there's nothing that a hearing would shed light on that analysis. I mean, we're talking about this from a more matter of law perspective.
Correct. I agree it's a matter of law and there's nothing that could be fleshed out at a hearing that would require testimony. And this was argued at the trial level as well. There was a written memorandum submitted after Hollis came out asking the court to also take that case into consideration before issuing a decision. So there's nothing that would help by remanding it, and I do believe it's a matter of law. What I would urge the court not to do is to consider an analysis where if conduct meets a crime in Ohio, then it's equivalent. And the trial courts want to do this all the time. They don't want to remove someone from a duty to register in Ohio because of the implications and the fact, Ms. Adams is saying this involved a toddler. Of course, this would be against the law. I mean, judges react differently to different types of cases. Whether it may be considered a rape in another case in another state, it looks egregious for different reasons to different judges, especially at the trial court level. And so I would just urge the court not to take into account the fact that just because the conduct would be illegal here under some statute, that is therefore somehow substantially equivalent now, because that's going to make the test much broader. And I think courts will just automatically apply it to any person coming into the state if they think they could be convicted of a crime here.
The conduct at issue in this case would be illegal under I mean, under Ohio, the statute that we're talking about, right?
Correct, Judge. Yeah,
Okay.
well, no, not under GSI. So the two statutes, one, I believe, are different. The conduct that's alleged to have occurred here would meet some offense under Ohio law, but I don't know that it would necessarily just on its face meet GSI.
Which element wouldn't it meet?
Well, okay, so first the court would have to consider going beyond the statute itself. So the court would have to first decide that it needs to look at other documents. And the only document that I think could be considered by the court in this case would be the final judgment and entry, and I'm just looking at the exhibits that were submitted at the trial level. And as well as an indictment.
Well, isn't the only thing that we need if we did use other documents is to determine the age of the victims? Because that's apparently the biggest issue here. That's the only issue, right?
Right.
Mens rea is the same. It's the age of the victims.
Well, under one section of GSI, then the mens rea would be the same. So yeah, the age of the victims is different. I also think there's differences in the type of sexual conduct. And looking at the definitions again, deviant sexual intercourse is much different than how Ohio defines sexual contact, which is just the touching of an erogenous zone of another.
So counsel, isn't Ohio, as far as the conduct, isn't Ohio statute broader?
Sorry, I apologize. I'm reading this statute again.
Well, it only requires touching.
It requires touching, correct?
Versus Kentucky requires more than that.
It does. It requires the organs of one person. I was looking at the exact subsection itself, involving the sex organs of one person in the mouth or anus of another, or penetration of the anus of one person by a foreign object, by any body part.
Which necessarily encompasses touching.
That's correct.
So Ohio is broader.
I would agree with that, Judge.
All right, Ms. Glacier, you are at your time, unless the panel has any further questions. Okay. Thank you both. Thank you both for your arguments this morning. We appreciate that. The case will be submitted and the court will issue a timely written decision. Wish you both a good day.